Do you need to say anything?
Yes, I'll go ahead, if you would allow me. This pretrial review is in the matter of case number CFI 114-2020 before Justice Lord Angus Glennie. The claimant is represented by BSA Ahmed bin Hazim and Associates LLP. Lead counsel is Mr. Antonios Dimitrakopoulos. The defendant is not present.
Yes, thank you very much. Mr. Dimitrakopoulos, what do you want to do? You want to kick off?
Yes. As Your Honour may be aware, this matter begun as being opposed by the defendant through the legal representatives it then had, who were Baker McKenzie. But as Your Honour was informed, just recently, Baker McKenzie came off the record. They removed themselves from the record. You'll find that in the e-bundle at B44.
I don't have this e-bundle. I've tried to find it. I've separately got the pleadings and everything like that, but I don't have the e-bundle.
Then I won't disturb Your Honour with references to the e-bundle. I'll just run you through the factual background.
Yeah.
If that's okay.
Yes, that's fine.
Yeah. So the only representatives for the defendant currently are the trustees allocated for the restructuring of the KBBO entities, if Your Honour may be aware, of which the defendant entity is one.
Yeah.
In this matter. So the default representatives would be the trustees of the KBBO entities. These are the people that have been copied into all correspondence following the removal of Baker McKenzie from the record.
And has there been any response from them to any of the emails?
Not that I'm aware of, no. Perhaps the registry can confirm.
Charlotte, is that right?
No emails from our end, no.
Yeah.
This is not surprising, Your Honour, because I think the trustees are busy with finalising a restructuring plan for all the indebted entities. So they're not in the process of legally representing the entities that may be sitting as defendants in cases such as the one before this court.
Can you just help me on this? Because I don't know what the position is in the UAE about this, but in the UK there is various processes by which you can restructure, and it puts a halt on legal proceedings pending restructuring and pending arrangements with administration and so on. Does the same situation apply in the UAE?
So there were various directives halting the proceedings in federal courts, all of which, as far as I'm aware, have lapsed because there were suspensions for a specific period of time. But in any event, those orders for suspension did not apply to the DFC court. They only apply to federal courts. Right. I believe I'm right in saying that even before the federal courts, these periods of suspension do not apply. There were in lots of 6 months that were renewed at various instances. But regardless of that, these are not relevant for DFC court proceedings because there's never been a directive specifically addressing DFC court litigation that it be suspended due to bankruptcy proceedings or otherwise.
Could you, when it comes to the trial, in your opening submissions, or written preferably, could you just summarise the position that you've just explained to me about both in the federal courts and the DIFC? It's useful to have this set out somewhere, and I may want to mention it in any judgment I give.
I made a note to do that, Your Honour.
Thank you very much. Yeah.
So, in short, it seems that we are heading towards an unopposed trial on 6th of March. Incidentally, the trial is booked for the 6th of March at 11:30 a.m. I'm not sure if Your Honour wishes to revise that in any way, but I'm just pointing it out.
Why was that?
I beg your pardon, why or where?
Why was that? It's an odd time.
Why 11:30?
Yeah.
I have no idea. It wasn't our choice, I don't think, but I'm not sure why.
The normal kickoff time would be either 9 o'clock or 10 o'clock UK time.
9
10
o'clock UK, which is 12 or 1, let's say.
10 o'clock makes 9 o'clock is quite sensible because it gives more time. Are you personally in the UAE?
I'm in the UAE, yes.
Your Honor, I apologize for interrupting. From our end, it appears that the hearing is listed for 1 p.m. Dubai time.
All right, that's 9. That's 9. But I'm not sure whether it will be 9 by then because we change the clocks at some stage. But it's listed at 1 p.m. Dubai time. Is that right?
Yes.
Right. I think there seems to be some confusion that it was originally listed at 11:30.
Yeah, just one moment.
Let's stick to 1 p.m. Dubai time.
Mm-hmm.
And I'm going to assume that's 9 a.m. UK time.
So I have at B45, I know Your Honour doesn't have the e-bundle, but at B45 we have an amended consent CMC order that at paragraph 11 says the trial of this matter shall commence Monday, 6th of March 2023 at 11:30 a.m. Dubai time. So
30 Dubai time.
That 11:30 a.m. Dubai time, which is quite early in the UK.
Yeah. What paragraph was that?
It's paragraph 11. Now, I might not have the latest version of the CMC, but it does say 6th of March, so that is the right date. And it does say 11:30, so if there's another version, it would only have changed the time.
No, I've got the 11:30 version. Right.
Yeah.
Well, let's amend that.
Okay.
Again, we'll make sure that
so
everything.
It's 1 p.m. for UAE time.
1 p.m.
Or is it 10 a.m. UK time?
No, 1 p.m. UAE time.
1 p.m. UAE time.
9 a.m. UK time. All right. So any order we make now, we'll amend that. Yeah. Okay. Should we keep the trial length of 3 to 4 days just in case at the last minute the defendants turn up? I suppose there's no harm.
Yes, I suppose there's no harm, but yes, I think it's unlikely, but
I think it's probably just within the first day.
We're in your hands on that, Your Honour, because obviously it will lock up a certain period of Your Honour's time.
Well, I think we've just think there's always a chance that defendants change their mind at the last moment. So I think we'll keep the estimated trial length. Can I just say that if it happened that we went all 4 days, which is unlikely, I know, I have to leave promptly at the end of the 4th day, the Thursday, and so we wouldn't want to go beyond 1300 or 1200 even on UK time on that Thursday.
I consider that eventuality unlikely, Your Honour. We have not prepared a timetable accommodating 4 days of trial.
No,
but we can do so. It's as a draft.
There's no purpose. We'll stick to the timetable you've put in, and we'll keep the days available in case at the last moment the defendant. But we'll note, Charlotte, can you note on any order we make that on the Thursday, if we're sitting, we'll have to stop sitting by 1300 UK time?
Yes, Your Honor.
Thank you very much. Right, sorry, I've been interrupting. You carry on.
Not a problem, Your Honour. Despite the fact that we're heading towards an unopposed trial, nevertheless, we understand that certain issues would need to be addressed regardless, even if the defendant is not represented. And those issues really arise from the defences articulated on behalf of the defendant when it was represented, some of which require that evidence of the relevant provisions of UAE law be adduced to the court in order to address the defendant's specific allegations made previously. So
this is on a question of apparent authority, or
correct, amongst other issues. Also, the significance of the issuance of payment certificates. They're all set out in our application, which Your Honour has approved recently.
when do you expect to be able to lodge an expert report?
Okay, so the order allowing our application to adduce UAE expert evidence was issued on the 24th of January this year. We had applied for it on the 19th of December last year. And although we had lined up UAE law experts, we couldn't formally engage, or the claimant couldn't formally engage them until, of course, we had approval by the court. So that happened on the 24th of January. I would respectfully submit that it might be difficult to meet the deadline contained in Your Honour's order, which is on the 7th of February, so 14 days after the date of issuance of the order. And I was wondering if I may request on behalf of the claimant a slight extension of that until, say, Friday the 17th of February. Would that be too much?
What's the position? Have you actually got an expert now?
We've got an expert, fully committed, paid for, signed a letter of engagement, ready to starting already working on his report as we speak. I'm just not sure whether he would be able to produce it by the 7th of February.
7th is what day?
Well, in 7th is it's a week today, so Tuesday.
Yes, and the trial's due to start on
a month later, after the allocated deadline.
Yeah. What about if you just had another week? So instead of
We're
the
in your
7th,
hands, Your Honour. We will comply with the deadlines you would allow. Another week makes it the 14th of February.
yeah.
14th of February. That's fine.
So we'll change that. We'll extend that time to the 14th of February.
I'm obliged to, Your Honour.
Right.
So that takes us to issues of factual evidence that we would need to deal with. There have been various allegations made by the defendants when they were represented, and we've sought to address those through the factual witness statement of Mr. Joseph Coutinho.
Yeah.
And he would be the only factual witness that we intend to call.
Yes.
What I propose, if Your Honour is agreeable to that, is that his witness statement constitutes evidence in chief.
Yes.
And that we just leave it at that unless the court has any questions to address to Mr. Joseph.
Yeah. That's fine.
So the next topic, I think, relates to skeleton arguments. Yeah. Now, the agreed CMC order refers to those at paragraph 16, and it says 4 days before trial. I just wanted to check if this is still acceptable to Your Honour. That's paragraph 16.
I don't have a paragraph 16.
You don't have paragraph 16? This is the agreed CMC order at B40. Let me just locate it.
Don't worry. It still says 4 days before trial, paragraph 9 of the one.
Yeah, I don't think that's amended. Yeah.
That's fine. 4 days before trial. You're happy with that?
We are happy, Your Honour. I'm just seeking your confirmation that this is still this can still be the case.
Yes. And you'll combine that with whatever. There's no point in two separate documents. Skeleton argument combined with a written opening statement or whatever. At the moment,
we propose to combine. We propose that the skeleton argument constitutes our written openings.
Good.
Which brings me to the next question that I presume that Your Honour requires oral openings.
I prefer oral opening, but it needn't be very long.
Indeed, we'll make a note of that. However, the question arises as to closing submissions.
Yeah.
Would Your Honour wish that those be oral as well? Our humble preference would be that they be written shortly after the trial, which is anticipated to be less than a day.
My strong preference is that they be oral.
You prefer oral, so within the same day to have a oral opening and an oral closing?
I'd be quite happy to give you the remains of the first day to prepare something and have it on the second day if you prefer. But I prefer the oral submissions to follow upon the evidence.
Understood. Yes, we're in your hands.
Whether you do it on the same day or the following day, it doesn't matter for me.
As long as they're oral.
Yeah, it's just that the written submissions, I think, are the bane of many judges' lives. They get longer and longer and more complicated, whereas an oral submission can sometimes put things together much more pithily.
Understood. Understood. We have often been limited when it came to written submissions by this court to say 20 pages or something of the sort. So that was addressed in that way.
Then people put appendices in and extra readings and anyway,
change the font.
Change the font, but given that the likely scope of the trial, I don't see that we need written submissions in this case.
Understood, Your Honour. We'll have oral submissions, and we may need a little bit of time to finalise them.
But you can take a decision later about that.
Understood.
Yep.
Which brings us to cost submissions. The question that we have, Your Honour, is should they follow the judgment or should they precede it?
They might as well precede it.
Proceed. Okay.
I can't imagine they were very lengthy, but they can precede it on the basis of anticipation of one result one way or the other, and you can say what you want to say both ways.
Understood.
Right.
I don't have any other issues unless I've omitted something fundamentally important. These were my notes so far.
You want an order that the hearing, including witnesses, be taken virtually?
Yes, Your Honour. I must say I made this presumption, but
somewhere in your checklist.
In the checklist, it's there. Yes.
6, you say you want directions allowing all witnesses to testify by video link. Yes. And so we'll just take an order that the whole trial proceed by video link.
Yes, please, Your Honour.
I don't think there's anything else that I can... hold on a second. There will be an agreed bundle, will there? Sorry, there'll be a bundle, whether it's agreed or not.
There will be a bundle.
Yeah.
And I don't think much would be added to it other than our opening skeleton submissions to what is available already.
And the expert report into.
And of course the expert report, yeah.
Very well. I don't think there's anything else that needs to be dealt with. Charlotte, is there anything we've left out?
Not from my end, Your Honour.
Right. Well, Charlotte, if you can draw up a draft order reflecting the points we've discussed, and then I can look at it, and if you email it to me. Is that all right?
Yes, will do, Your Honour. Mr. Antonios, do you by any chance have these notes? Could you share them with the registry so we can ensure we're not missing anything?
Sorry, you would like some sort of summary note from my end?
I was just asking if you took some notes
I did.
that you could share. Perfect.
I did, and I can do so, yes, certainly.
Now
that they're fresh.
Yeah. Can we have we include within the order that all communications from until further notice be copied to the and name them the trustees?
The three trustees, yes.
And make that part of the order so that there's no doubting what's happening. Very well. Thank you very much. So that's all then, I think, and we will meet again on the 6th of March.
Indeed.
Thank you very much.
Thank you very much, Your Honour.